In cases of battered woman syndrome, it must have cycle of violence such as tension building phase, acute battering phase, and tranquil loving phase. Good morning everyone. For today's video, I will discuss about the different circumstances that will affect criminal liability. So under Article 11 of the revised penal code, this provides the justifying circumstances, and there are six different justifying circumstances to be invoked by a person who admitted in the commission of the crime. Now, we will define of what is justifying circumstances before we will proceed to the different defenses under Article 11 of the revised penal code. So, justifying circumstances, it is an act of a person which is to be considered as in accordance with the law and does not have to have transgressed the law, or his acts are free from any criminal and civil liability. However, there is one paragraph under Article 11 of the revised penal code which provides civil liability, and that is under paragraph 4 on the doctrine of state necessity, or on the avoidance of greater evil or injury. Now, here is the common questions for us when a person, or what are the consequences of the accused who invoke justifying circumstances on the ground of self-defense. The consequences of a person or the accused who invoke justifying circumstances is that he admits the commission of a crime. However, upon admission in the commission of a crime, he asserted that his acts was in accordance with the law, that his acts are within the purview of Article 11. Say for example, under paragraph 1 of Article 11, that he acted as part of his self-defense, or he protect his right against life or property. So that is an example of an act which is in accordance with the law, provided also that all the requisites provided under Article 11 are present. Now, since the person admitted the commission of the crime and invoke, say for example, on the ground of self-defense, our next question is, what is the evidence or the burden of proof required in order for him to be acquitted or in order his act to be justifiable. Now, let us enumerate the four hierarchy of burden of proof or evidence on any different liabilities. Now, when we talk of criminal liabilities, the burden of proof required is that the so-called proof beyond reasonable doubt. Proof beyond reasonable doubt is the proof or the burden of proof required in criminal liability or in criminal crime or criminal offense. Now, second to proof beyond reasonable doubt is the so-called clear and convincing evidence. That clear and convincing evidence is the evidence requires when you invoke justifying circumstances. I repeat, when we talk of justifying circumstances, the evidence required or the proof required is that clear and convincing evidence. Now, on the third hierarchy of evidence is the so-called preponderance of evidence. When we talk of preponderance of evidence, it is the evidence required for any civil liability or any civil offenses that you have committed against the other party which you prejudiced their rights. Now, on the fourth hierarchy of evidence or proof required is the so-called substantial evidence. This substantial evidence is required on cases involving administrative cases or administrative matters. So, ang required here is substantial evidence. Now, going back to the evidence or proof required when you invoke justifying circumstances on the clear and convincing evidence. On the clear and convincing evidence, you should rely on the strength of your evidence and not on the weakness of the defense. So since you already invoke that your acts or that you committed such acts but you invoke justifying circumstances, now the burden of proof instead on normal cases or normal procedure, it is on the prosecution. But now, since you invoke justifying circumstances, the burden of proof is on your favor already. So, dili na si prosecution ang naay burden of proof, kundili ikaw na nga ni-invoke of self-defense. Now, we will proceed on the first justifying circumstances under Article 11, and that is the so-called self-defense. This self-defense is very common to us. It is very useful defenses for us. So, under paragraph 1 of Article 11, that anyone who acts in defense of his persons or rights, provided that the following circumstance concur or the following requisites are present. So, first is the unlawful aggression. Second is reasonable necessity of the means employed to prevent or repel it. Third, lack of sufficient provocation on the part of the person defending himself. Now, let us discuss about unlawful aggression. What is unlawful aggression? Unlawful aggression, it is considered as a physical assault or a physical attack that will imperil to the life or limb of a person. And in fact, there are two kinds of unlawful aggression. We have the physical unlawful aggression and the imminent unlawful aggression. There is also an instances where an aggression becomes lawful. Say for example, in the performance of a police officer to arrest a person using a reasonable force in the performance of his duty is considered as a lawful aggression. Because that is his duty to arrest a person. Most especially when that person committing the crime in his presence. Therefore, such aggression committed by a law enforcement officer is lawful. Now, we will go on the so-called unlawful aggression. I have already mentioned that unlawful aggression is divided into two. We have the physical unlawful aggression and the imminent unlawful aggression. So when you talk of physical unlawful aggression, meaning to say that the act of the person is, or the offense is positively strong, that the intent, or you can determine the intent of the aggressor. While on imminent unlawful aggression, the act is on the point of happening. It is not a mere threatening act, or shall we say, you need to determine the intent of the aggressor. An example of an imminent unlawful aggression is when someone aiming you a revolver that is about to squeeze the trigger, or by opening a knife in your presence that you're going to stab uh, on you, or when there is a positively strong attack against you, meaning imminent unlawful aggression, it is on the point of happening. While physical unlawful aggression, that act shows only the intent of the aggressor, and that is to kill the other person. See, for example, when A drawing his gun and he has the intent to kill a person, such act of drawing his gun cannot be considered as an unlawful aggression. Why? Because such act of drawing his gun does not constitute any imminent danger or that will imperil to your life or limb that will constitute on the act of drawing his gun. Maybe after he draw his gun, is iyahan ng ipanghadlok nimo or i-discharge, commit ba siya og discharge of firearm or alarm ng skandal. Therefore, the act of drawing a gun does not constitute unlawful aggression. Now, in the case of people, knock-knock versus people, this case involves a trained police officer where the act of drawing a gun is considered already as unlawful aggression. So meaning to say, it depends upon the circumstances whether such person is an ordinary person who does not know about basic marksmanship or basic functions of a firearm, then the act of drawing cannot be considered as an unlawful aggression. On the case of knock-knock versus people, since he is a trained police officer, the act of drawing a gun is already considered as an unlawful aggression. Why? Because being a trained personnel, so he can act immediately or promptly to draw a gun and then immediately squeeze the trigger to kill his target. So that is the difference between an ordinary people and a person who is a trained officer. And in fact, such case on knock-knock versus people is still controlling. Now, there are also another act that will constitute unlawful aggression. And that is the act of slapping. The act of slapping on your face. So, sagpaon ka diha, nakay kasugat sa karsada, kahit lakag sagpa, that is considered as an unlawful aggression. Why? Because your face represents yourself as a person, and it also represents your dignity. That is why, kung sagpaon ka sa sagmaon ng imuhang naong, so consider na siya og unlawful aggression. So napata sa unlawful aggression, wala pa ta ni proceed on the second requisites para i-apply na to ang self-defense. Another example, kung pananglitan na kay, for example, best friend dayon, gipaagi niya og joke or gipaagi niya patid as kanang ni-greet siya nimo og kanang good morning pero gipatiran ka, then makonstitute ba na siya og unlawful aggression? For example, kusog ang pagpatid, may nakabay, kumusta bay, ana? So such act of foot kicking nga gi-consider niya as greetings to his best friend is not considered as an unlawful aggression. Why? Dili siya unlawful aggression nga naman ang imuhang life is not in danger. Your life is not in peril. Ang imuhang limb is, or life and limb is not in danger. Nga gi-greet la ka diha sa imuhang kanang amigo pinaagi sa pagpatid. So ayaw sa og koan balos nga mayo na ka, ay nanay unlawful aggression. So pwede na ko ani mag self-defense. So dili sayop sad na siya. So tan-aw nimo kung ang iyahang gihimo is makabutang na ba nimo sa kaalaot, mahimo na ba nga matawag nimo ay my life is in danger. So, pwede na nina kung i-apply ang gitawag nga self-defense. Provided nga the three requisites must be present. Kinahanglan na ang three requisites. Otherwise, dili ka maka-apply og justifying circumstances. Maybe, pwede ka mo-apply og mitigating circumstances. So, ato rin siyang i-discuss as we go along with our topics on the different circumstances that will affect criminal liability. Now, importante ba gyud nga naa si unlawful aggression? The answer is yes. Unlawful aggression is a condition sine qua non, or it is necessary. It is a preceding condition nga kinahanglan nga naay unlawful aggression para mosulod ang self-defense. Kaya kung wala na si unlawful aggression, of course, dili ka maka-apply sa self-defense. So what I have mentioned earlier about the lawful act of the police officer to effect the arrest of a person committed a crime in his presence, so considered siya as lawful aggression. Why? Because he exercises his performance of his duty. Naay presumption of regularity in the performance of his duty nga iyahang gi-arrest ang katong tawo nga ni commit og crime in his presence. Okay. Now, I hope you understand about unlawful aggression. So, basta ang iyang timanan about unlawful aggression, bisan pa og giyaw-yawan na ka diha, giinan ka, see for example, giinan ka nga, patyon ti ka, without any attack, it is a mere threatening, or gitreat lang ka diha nga patyon ka, such act, dili pa siya makonsider nimo as unlawful aggression. Diba? I already differentiate between the physical unlawful aggression and the so-called imminent unlawful aggression. Kay para man good mosulod ni siya si unlawful aggression, there must be the so-called physical or material attack. Physical or material attack. And then second, such attack must be, or such assault must be of least imminent danger. Nga na makahatag siya imminent danger on the part of the person nga ning dipinsa siyang kaugalingon. And third, such attack must be unlawful. Kinahanglan siya unlawful para makonsidered siya nimo as of course as an unlawful aggression. Now, I hope you understand so that I can proceed on the second requisites under self-defense. So, reasonable necessity of the means employed to prevent or repel it. This is the second requisite under self-defense, paragraph 1 of Article 11. So, this second requisite under paragraph 1 explained about not on the absolute necessity, but on the so-called doctrine of rational equivalence. Why? Because as a person who want to suppress or to prevent the attack of the aggressor, is dili na ka maka huna-huna to think of what is the necessary equipment nga imuhang gamiton in order to prevent the attack of the aggressor. That is why dili siya moingon nga absolute necessity. Dili siya moingon nga material or mathematical calculation or material gitawag nga commensurable nga ay ang gigamit ni aggressor is kutsilyo. Ay kutsilyo sa akong gamiton. Ay ang gigamit ni aggressor bato. Ay bato sa akong gamiton. Muna giingon nga dili siya absolute necessity. Because when a person is attacked by the aggressor, you cannot really think og unsay imuhang buhaton in order to suppress sa iya nga pag-attack. Dili kay kita ka ay kutsilyo. Ko ginamangita sa kutsilyo kay para naa kay makaingon kag reasonable necessity of the means employed to prevent or repel it. What is required is that there must be a rational equivalence and not a material commensurable or the mathematical calculation. Meaning of a rational equivalence, imong tan-awon ang situation because mayong kag reasonable necessity, wala lang ka nagbase on the equipment or the tools being used by the aggressor. You should also consider those circumstances in order for you to protect, in order for you to prevent, in order for you to suppress such attack coming from the aggressor. See, for example, the character and size of the aggressor is dako kayo, gamay ka. So kay ang iyahang gigamit kutsilyo, mangita sa kag kutsilyo, no. Mangita ka og pamaagi in order to prevent. Say for example, nakapunit ka diha og bato, imong napukpok sa iyang napatay nimo. Of course, ang imong gigamit is reasonable necessity or the means employed to prevent or repel it. Ha? Daghan og mga circumstances. Tan-aw nimo ang iyahang gidak-on, iyahang, of course, ang iyahang ability baron. Si for example, naa siya yung mga na taekwondo baron siya, ingon ana, imo siya na siyang i-considered nga para maka-apply ka og reasonable necessity. Again, ang reasonable necessity is wala nagpasabot og absolute necessity. Wala nagpasabot og mathematical calculation. Wala nagpasabot og material commensurable. What is required is only a rational equivalence for you to prevent and to repel the attack of the aggressor. Understand? Now, lack of sufficient provocation on the part of the person defending himself. It is very important that the first and second requisite must be present when you invoke self-defense. Otherwise, kung maglacking ganin siyang requisites, wala si reasonable necessity, wala si unlawful aggression, of course, wala na kay mahimo diha nga self-defense. Why? Because, balik ko na ko, unlawful aggression is a condition sine qua non. Meaning to say, it is a precedent condition which is necessary for you to invoke justifying circumstances on the ground of self-defense. Now, lack of sufficient provocation on the part of the person defending himself. Meaning to say, on the part of the person defending himself, dili kay si stranger, dili kay si laing tao, but on the part mismo sa person nga nidipinsa sa iyang kaugalingon. Now, ari na to isulod sa gitawag na to nga no provocation at all. Ha? No provocation at all. Say for example, si A naglakaw, naa si B. Naay problema si A sa iyahang gidadala nga problema, nagdala siya og kutsilyo. Na nakita niya si B, galagot siya. Without any provocation at all, ha? Without any provocation at all, walay panaglalis, walay istorya-istorya, gidargon niya dunggab. Ha? Gilargon niya og dunggab si B. So, with that example, makita nato nga walay provocation at all. So, therefore, wala may provocation at all. Atong sumpayan ang atong example. Gikuha ang kutsilyo ni B, pagkuha niya is diri na sa iyang tiyan. Napaman siya kinabuhi. Iyahang nadunggab ni A. Ha? Iyahang nadunggab ni A. Silbi nakabalo siya. Nadunggab ni A. Ang nasambad ni A is fatal wound. Og nahiresulta sa kamatayon ni A. So, pwede ba natong i-apply ang self-defense karon? So, on that example, pwede na. Nga naman, unlawful aggression. Ato apply. Unlawful aggression. Is there a lawful or unlawful aggression? Lawful ba nga manunggab ang usa ka tawo og largo diha nga way hinungdan? Nga dili siya peace officer, nga wala sa siya nadakpan sa akto? Lawful ba? The answer is no. That is unlawful aggression. Ha? Unlawful aggression. Second, reasonable necessity of the means employed to prevent or repel it. Reasonable ba nga giibot ni B ang kutsilyo para makasukol siya or makabaw siya para dili mapun-an ang injury nga mahatag ni A kung pananglitan wa niya gikuha ang kutsilyo niya. Pananglitan nato do problema, di ba? May problema to si A nga og sige tugdugsak, of course mamatay si B. Reasonable ba yang gihimo gikuha ang kutsilyo og gidunggab ni A? The answer is yes. That is reasonable. Why? Di ba ningon taganiha sa reasonable necessity, dili na mong ingon nga absolute necessity. What is required is the doctrine of rational equivalence. Based on the circumstances, based on the character, and based on the size of the person or on the aggressor in order to prevent or suppress the attack of the aggressor para maprotektahan niya ang kaugalingon. Muna gitawag na ito reasonable necessity. Okay? Now, on the third requisite, lack of sufficient provocation on the part of the person defending himself. At sa person defending himself, kinsa man ang person nga mo defend siya himself? Of course, si B. Nga naman, siya may gidunggab. Naabay provocation? Ningon ko ganiha, no provocation at all. Sulod ba? Yes. Lack ragani now, lack of sufficient provocation. Meaning, dili gid siya kaayo, insakto nga makaprovoke sa usa ka tawo. Kato sa ko example, kay wala gyud. Gilargo ra siya dunggab. Of course, with that example, masulod nato sa gitawag ni na self-defense. Masulod na to si paragraph 1, self-defense. Nagkasinabot ta. Now, arita sa lain nga provocation. Lack of sufficient provocation. Ato i-apply. So, na si A. A na sadda. Na si A, gibadlong niya si B. Kaya nga naman, gibadlong niya si B, kay gikuralan og apil ang iyahang yuta. Ha? Gikuralan. Ginan niya, bay, B. Kanang, palihog ko og sibog ana imong gikural, kay ning lapas na ka, naana ka sa ako ang yuta. Og sa dihang nasuko si B. Pagkasuko ni B, naaman siya yung mga gamit. Ha? Kuan murag ihampas pa dong sa martilyo ba? Nya, naigo gyud si A. Ha, naigo si A. Naigo si A na abaga, mura na commotion. Pak, na commotion. Now, nailog but si A bisan pag nailog akong butangan og clarification. Nailog ni kay maabot man gud ta sa retaliation ron og self defense basin maingon mo nga maglibog na mo. So, akong ingon nga nailog ang martilyo ni A. Pagkailog ni martilyo, nagsigi ra gihapon si B og attack ni A. Now, pag humag-ilog is nakabaho si A, nahapak sa O ni B. Namatay si B. Now, pangutana, maka-apply ba ta og gitawag nato nga self-defense based on that example nga si A ang ning una og hatag og provocation? Ha, nihatag ni provoke man siya. Nihatag siya provocation ngadto ni B based sa iyang pagbadlong ngadto ni B. Maka-apply ba? Yes or no? The answer is yes. Ha, maka-apply ta og self-defense. Why? The fact nga gihimo ni A, nga gibadlong niya si B, nga bay, ayaw apila akong yuta og koral, ayaw og koral kay ayaw silibi isibog ang koral kay ning abot na ka sa ako ang luna or sa akong yuta. So, such act, katong gihimo ni A, is considered, katong gihimo ni A, is considered na to siya, o gitawag nato nga, lawful. Nga naman, lawful siya, kay of course, makay rights imong property, imong ingnon nga, protektahan ako ang property, o ayaw na, o korala, kay ako man na siya nga, yuta. Now, asa ni sud si unlawful? Nisud si unlawful aggression sa katong gihimo ni B nga paghapak og martilyo ngadto ni A. Nga naman, man siya right, di man lawful ang iyahang kanus man na lawful nga mo inflict kag injury to another person. Di ba? Unlawful man na siya. It is prohibited by law nga mo inflict kag injury. Now, sulod ang first requisite. Kinsay namatay? Di ba si B? Kinsay ni Ona? Di ba si B? Ang gihimo ni A is lawful kay iyaham ng right to protect his property. Ha? Now, unlawful aggression ha. Una, reasonable necessity. Of course, reasonable gihapon. Baliko na ako, wala tang nag-require diha og materia or mathematical calculation. What is required is the rational equivalence para lang masulod si reasonable necessity. Now, lack of sufficient provocation on the part of the person defending himself. Di ba makonsider na to og lack of sufficient provocation ang gihimo ni A? Dili na to siya maingon nga kuan gid siya exactly nga sufficient or enough nga para mo dipinsa. Nga mo dipinsa sa gitawag nato nga si B nga dipinsaan niya kay in the first place wa man siya right to protect. Kay di man siya owner sa lahat nga akong dimension. Si A man ang tagiya. Now, napatay ni A si B, si A pwedeng maka-invoke og self-defense. Nasabtan. Now, let us differentiate between retaliation and self-defense. When we talk of self-defense, of course, it is justifiable. Why? Because it is provided under paragraph 1 of Article 11. Now, ang retaliation is different from self-defense. So, example. Si A, balik ta. Si A, ni badlong, ni B. Now, si B, ning, so-called silbi, tungkol sa, na-provoke, kay gibadlong, gihapak martilyo. Sige, hapak. Now, nakuha na ni A ang martilyo. Nakuha ni A ang martilyo. And pagkakuha ni A sa martilyo, ning atras si B. Nga mura siya og mudagan. Ni atras si A Ni atras si B. Ni atras si B. Nga mura siya og mudagan. Now, gigukod gyapon siya ni A. Gigukod gyapon siya ni A. Pero si B is wala na siya intent nga musukol pa. Nihunong na siya. Now, gigukod gyapon ni A. Hantod nga naabta ni A og giihang gidukduk-dukduk sa martilyo pag maayo og namatay si B. Now, on that case, nga akong or that example or facts nga akong gihatag, can A invoke the doctrine of self-defense based on that facts that I have mentioned? The answer is no. Why? Because during the time nga nakuha ni A ang martilyo og nipalayo na si B, na-cease na, meaning na-stop na ang aggression or ang unlawful aggression nga gihimo ni B. Nga naman, from that time nga nakuha na ni A ang martilyo, there is no such thing nga iyang i-protect. Nga naman, ang iyang life is not in danger. Why? Kay na naman niya ang martilyo og nipalayo na si B. Therefore, na-cease na, ni-stop na ang unlawful aggression ni B. Now, gigukod ni A. Gigukod hantod iyang gidukduk sa martilyo, namatay si B. Dili na siya maka-invoke of self-defense. Nga naman, gitawag na nato siya og retaliation. Kanang retaliation, ma-held liable na si A sa iyang gihimo. Kay wala na siya self-defense to speak of. Okay? Nasabtan? So, para masabtan niyo pag maayo, we should also distinguish these three terminologies para atuhang mapasulod sa tanan nga mga acts nga gihimo sa usa ka akusado. So, what is imputability? Para masabdan nato. Imputability, it is an act of a person which is nga ascribed as the author or owner that he acted freely and consciously. Meaning, iya just nang gihimo. Iyang intent nga mohimo siya ana. Muna gitawag na tog imputability. Now, on the other hand, when we talk of responsibility, it is the consequences of your act. Based sa imong gihimo, ganiha, nga ikaw ang author or owner of such acts, nga freely and consciously nga imo nang gihimo, of course, if there are penal prohibition of your acts, therefore, you should suffer the consequences of your act. Muna gitawag na to og responsibility. Now, alita sa guilt. Guilt is one element of responsibility. And a person to be considered responsible to the act, of course, he must be guilty on the acts that he has committed. Nasabtan? So, balik ta. Ari sa atong giingon ganiha nga nindaga ni si B, dayon gigukod ni A. So, kinsa may naghimo ato? Of course, i-impute na to kay iya man gihimo. That is imputability. Siya responsible ato. He should suffer the consequences of his act. And then, kung mapamatud-an that he is responsible of such act, ngayang gihimo, of course, mahimo siyang guilty. Dili nato siya ma-apply sa self-defense. Kaya nga naman, nisulod na si retaliation. Okay, nasabtan. I hope you understand the self-defense, Next is the so-called defense of relatives. So, what do you mean by defense of relatives? So, of course, defense of relatives is ang pagprotekta. Giprotekta ra nimo ang imuhang mga kaliwat. But, atong i-determine, kinsa man ang mga kaliwat, asa ra man kutob nga para masulod si defense of relatives. So, paragraph 2. Those who acts in defense of a person or rights of his spouse. Di man spouse. Asawa, imuhang bana. Ascendants. Ascendants. Imuhang grandparents. Imong descendants. Imuhang silbi mga apo. Dayon, legitimate. Meaning, imuhang anak. Imuhang anak. Baron, legitimate. Yung tag-legitimate ni mga anak is of course by virtue of a marriage. Otherwise, kung dili na nimo na anak nga within the valid marriage, of course, that is considered as illegitimate child. And kung, for example, atong i-appeal ang illegitimate child, meaning to say, nataw ang bata, wala pa ang kasal. But walay mga legal impediment nga makapa-prohibit sa ilahang pagkasal. And then, until such time nga nakasal sila, gipa-legitimate ang bata. Muna gitawag natog legitimated child. Now, balik ta sa legitimate child. Bingotag legitimate, of course, nataw siya within the valid marriage. Natural or adopted brothers or sisters. Remember ha, kay para masulod nato si defense of relatives or of his relatives by affinity in the same degrees. So, unsa man ang gitawag nato nga relative by affinity in the same degrees or relative by affinity. So, when we talk of relative by affinity, meaning to say, ang inyong relationship is by law, by marriage, ha? And not by blood. Kay maingon galitag by blood, that is relationship na siya by consanguinity. Tima niha, consanguinity, relationship by blood. Maingon tag affinity, that is relationship by law. Ha? Kay nagka hatag relasyon kay tungod sa, for example, sa kaminyoon. Okay. Within the fourth civil degree. Unsa may gipasabot nga fourth civil degree? So, tagaan mo instant nga gitawag nato nga relationship within the fourth civil degree. Second degree, second civil degree is brothers and sisters. Brothers and sisters. Third civil degree is kanang inyohang mga uyuan. Nis, uncle, muna inyohang gitawag og third civil degree. Now, kay ang giingon consanguinity within the fourth civil degree, muna gitawag na to nga inyohan ng first cousin. First cousin ninyo is the fourth civil degree. Now, kung musulod ka ana nga mga gipang-mention nako, then pwede na masulod na to si defense of relatives provided that the first and second requisites prescribed on the next preceding circumstance are present. Unsa may gitawag na to nga next and prescribed next preceding circumstance are present. First and second. Of course, katong gitawag nato ganiha nga unlawful aggression, reasonable necessity of the means employed to prevent or repel it. Kinahanglan na siyang duha. And in case was given by the person attacked that the one making the defense had no part therein. Mao ni imong third requisites. Gikuha na nimo si lack of sufficient provocation on the part of the person defending himself. Nganong gikuha man na diha? Kay wa makay appeal. Wala kay appeal ni abot ra kag kalit para iprotektahan ang imuhang pamilya, imuhang kaliwat. So, example, A and B nagsinukmagay, nagsinukmagay si A and B. Si B imuhang papa. Now, nalupig imuhang papa kay si A, si for example is naaday siya gidadala nga sundang. Now, about na nga ihak or tigbason ng imuhang papa. Dahil nakita nimo, nagdagan ka, gidagan nimo. Kay para maprotektahan imong papa, kita kag binugap, imong gibitbit, gapak nimo ang O ni A. Padung na gidong ta itigbas, pero naunhan nimo si A, nga matigbasan ang imuhang papa, ug nabunala nimo ang O ni A. Namatay si A. Pangutana, ma-held liable ba ka? So, based on that facts that I have mentioned, dili ka ma-held liable. Nga naman, again, pwede ka mo invoke of defense of relatives. Paragraph 2, defense of relatives. Atong tagsawa ng requisites. Unlawful aggression. Is there unlawful aggression? Yes, there is an unlawful aggression. Nga naman, regardless og kinsay nanguna sa imuhang papa og ni A, as long as you don't have any idea, but your intent is to protect the life of your father, then there is or there was an unlawful aggression. Kinsa ba yung nga lawful nga patio na nimo ang imuhang isig katawo, di ba? Unlawful man na. Therefore, sulod si unlawful aggression. And the act of hacking, padung na tigbason, is matawag nato og imminent unlawful aggression. It is in the point of happening. It is in the point of happening. Now, unlawful aggression arita sa reasonable necessity of the means employed to prevent or repel it. Nagdag sundang. Sundang. Kinahanglan ba nga si C nga anak ni B mudagan pa sa ilaha kay magag sundang kay mingod reasonable necessity. Kinahanglan sundang akong pangitaon kay sundang nga gigamit. No. Again, what is being required by law is the doctrine of reasonable rational equivalence. As long as ma-prevent nimo or ma-suppress nimo ang paghimo sa usa ka krimen, then such act is considered as reasonable necessity. Now, ang pagkuwag binugha o pagpunal sa O ngadto ni A para ma-prevent ang pagpatay sa imong papa is considered as reasonable necessity to prevent or repel it. Ha? Kuha na ang paragraph second requisites, ha? Unlawful, okay, check. Reasonable necessity, check. Now, arita sa that the one making the defense had no part therein. Ayaw na to gamita to si lack of sufficient provocation. Kay klaro man kay ito nga lack of sufficient provocation on the part of the person defending himself. Karon ang pwede nga mo apply unta ana supposedly is si B. Nga naman siya may kakontra, ha? Lack of sufficient provocation on the part of the person defending himself. Timanin na ninyo para musulod sa self-defense. But now, ang ako is nanata sa paragraph 2. Nasa defense of relatives. Unsa itong tanaw ng third requisite? The third requisite is that the one making the defense had no part therein. Based on the facts that I have mentioned. Naa ba si A? Ay naa ba si C? Sa panahon nga nag-away si A o B? Apil ba siya sa panaglalis? Naa ba'y provocation nga nahitabo against niya? Naa ba? Based on the facts nga ako ang giingon? The answer is no. Nakita na lang niya ang iyang papa nga nahigda nga padung tigbason. Therefore, masulod nato ang gitawag nato nga that the one making the defense had no part therein. Nasabtan? I hope you understand. Defense of relative. Ang pinaka-importante lang sa defense of relative is ang kining mga relatives, spouses, ascendants, descendants, legitimate, natural, adopted brothers and sisters, dayon relatives by affinity in the same degree, and of course, consanguinity within the fourth civil degree. Timan ina, kay maato nang maghamit inig-abot na to sa defense of strangers. Another example. When A, giprotektahan niya ang husband of A's sister-in-law. Sister-in-law, A's husband, sister-in-law. Pwede pa ba siyang maka-invoke og defense of relatives? I mean, the answer is no. Nga naman, ang giingon na to relative by affinity in the same degree. Sister-in-law, brother-in-law, son-in-law, parent-in-law. So diha ra ka pwedeng mo-apply kay giingon sa provision under paragraph 2 is relatives by affinity in the same degree. Kuha. So di na pwede ito nga ma-defense of relatives. Pero pwede ta mo abot sa third paragraph which is defense of stranger. So mabot ra taron. Ay lagay mo ka excited. So balik ta. Arita sa consanguinity within the fourth civil degree. What if ang ning tabang is si itawag nato og second cousin na, dili na si first cousin? Masulod ba sa defense of relatives? The answer is no. Why? It's very clear under paragraph 2 of article 11 that those by consanguinity within the fourth civil degree. Fourth civil degree is equivalent to first degree cousin. Nasabtan. Balik ko na tong requisites since ang requisites is pinaka-importante. Mao ni pinaka-importante kaya nga naman multiple choice man ang papilian sa board exam. So when we talk of self-defense, of course, unlawful aggression, reasonable necessity of the means employed to prevent or repel it, and lack of sufficient provocation on the part of the person defending himself. Then when we talk of defense of relatives, of course, unlawful aggression, reasonable necessity of the means employed to prevent or repel it, and the person making the defense had no part therein. Sabtan. So let us proceed to the defense of stranger. So defense of stranger. Ang atong unang pangutana when we talk of defense of stranger is that who are those person considered stranger? Di ba? Kay para makibaw ta nga stranger siya. Who are those person considered strangers? Of course, by definition of the law, those persons are considered stranger are of course those persons not enumerated under paragraph 2 of article 11. Dili si spouse, dili si ascendants, dili si descendants, dili si legitimate, natural, or adopted brothers and sisters, dili si relatives by affinity within the same degree, and dili sad si relative by consanguinity within the fourth civil degree. of course, wala siya nakadefine dito under sa defense of relatives. Outside ana niya nga ning tabang is matawag nato nga stranger. Okay, nasabtan? So, katong sa ko example ganiha nga si A, giprotektaran niya ang husband A's sister-in-law, is masulod na siya sa ato sa defense of stranger. So, say for example, si A is a peace officer, dayon si B is law violator. Naa si C, kauban ni A as a peace officer. Now, ni commit og crime si C, ni commit og crime in the presence of A. Commit og crime. Dayon, niingon si A, B, palihog ko og example, kung ano mong sanina, kay para matanaw og naaba siya ay mga gitawag nato nga gipangtaguan nga mga deadly weapon nga pwedeng makasukol nga nagkandak og search incidental to lawful arrest si peace officer. So mo na iyang i-determine ha, basin na ay mga deadly weapon nga pwedeng madunggaban si peace officer. Now giingnan siya ingon ana. Sa pag-ingon ni peace officer nga mao na ikuha ning imong bulsa, ikuha ning imong sanina ning atras, ha, one step backward. Pagkahuman one step backward is ning bunot o gitutok nga padung na squeeze ang trigger para pusilon si A. Now naa si C. Pagkita ni C nga padung pusilon si A, ha, pusilon na ni B si A, iyang giunahan og pusil si C. Nga ato lang i-apply for purposes of discussion, i-apply nato ang defense of stranger. Ha? Dili sa tama about dito sa performance of lawful exercise of his duty of performance or lawful exercise of his right or office. Ha? Defense of stranger sa ta. Now, iyahang gipusil. Now, namatay si B, of course. Karon, unsa ang depensa nga gamiton ni C as peace officer? Ngayang gitabangan si A nga nana siya sa point of death ato. Kay kung wala pa to, pwedeng mapatay si A. Now, unsa yang gi-apply? Atong i-apply na to is defense of stranger. Ha? Defense of stranger. Nga naman, wala may relationship between si A and B, ay A and C. Kay kauban naman sila sa trabaho. Dili niya, of course, dili niya igsuon. Of course, dili siya relative within the itawag nato nga within the fourth civil degree. Pero og atong isulod ang definition under paragraph 2 para ma-defense of relative, for example, igsuon silang duha, pareha sila peace officer, din protection na niya. Of course, musulod da didto, ha? Provided nga naa ang third requisites, had no part therein. Timanin na ha, wala siya labot sa panaglalis, ha? Para musulod sa defense of relative. So, let us proceed on the defense of stranger. I hope you understand the difference between defense of relatives and defense of stranger. Ha? Sa mga personalities sa tata dito sa gidefine sa paragraph 2 o sa paragraph 3 kay lain na sa ni siya og tawag nato nga essential requisites except sa first and second. So, sana to? Anyone who acts in the defense of person or rights of a stranger, provided that the first and second requisites mentioned in the first circumstance of this article are present, and that the person depending be not be induced by revenge, resentment, or other evil motive. Now, unsa to ang first and second requisites? On the first circumstance of this article, unsa gito yung first circumstance? That is self-defense. Unsa gito ang first and second? That is unlawful aggression. Ha? And I presume you already understand about unlawful aggression, ha? Pinangatiman-an ninyo sa unlawful aggression nga that your life is in danger. Ginaragay ka diha, huy batikag naong, pusilong ti ka, dili pa na mo constitute og unlawful aggression. Ha? A mere threatening act, or bisan pag ginagawi migo, kumusta, patid ang gihimo, so dili pa na siya unlawful aggression, kay slight provocation pa na siya. Ha? Timan slight ra na siya. Pero og imuhang naong sagpaon gani, of course, constitute na siya unlawful aggression. Nga naman, kay your face, dili sounds familiar ha, your face represents your self as a person, and of course, it also represents your dignity. Ha? Mo na pwede na kang tawag na to reasonable necessity of the means employed to prevent or repel it. Okay. Now, balik ta dire sa defense of stranger. Sulod, unlawful aggression, naa. Ikaduha, reasonable necessity of the means employed to prevent or repel it. Atong i-apply. Unlawful aggression? Yes. Ha? Kay lawful ang gihimo ni peace officer A nga iyahang ipakuan ang iyahang mga bulsa or iyahang sanina aron mahibaw-an kung naa ba siya mga deadly weapon in order to protect also sa iyahang life ni A. Kay basin naa na tinaguan, madunggaban pa lang, di ba? Now, unlawful aggression. Yes, unlawful. Nga naman, dili man unlawful nga mo disobey ka sa command ni peace officer because he is exercising in the performance of his duty and in fact he committed a crime prior nga giingnan siya nga kana ang ikuan ang imuhang bulsa or imuhang sanina para makita nga naa ba siya tinaguan, di ba? Ningon ko sa kong example ganiha nga naka-commit siya crime, nagkandak og search incidental to lawful arrest si peace officer. Now, unlawful ang gihimo ni B. Yes, unlawful. Second, reasonable necessity of the means employed to prevent or repel it. Reasonable ba? Yes, that's reasonable. Reasonable. Ang naman, of course, peace officer good siya, ang gigamit firearm, nasa si firearm, of course, iya ginambanatan, lain sa kay mudagan pa siya, ang siya laing gamit. Di ba? Wala na. And that the person depending be not be induced by revenge, resentment, or other evil motive. Naabay kalagot si C? Nga iyahang posilon si B? Naabay siya mga evil motive? Naabay siya resentment? Of course, wala. Nga naman, he is only performing his duty. Ni-perform na siya duty. Of course, kay sulod man ang tulo ka requisites, atong i-apply ang defense of stranger. Nagkasabot ha. Unsay kalainan gani? So, ato na sang kuan para dili maglibog, self-defense, unlawful aggression, reasonable necessity of the means employed to prevent or repel it, lack of sufficient provocation on the part of the person defending himself. Muna siya, self-defense, arita sa defense of relatives, unlawful aggression, reasonable necessity of the means employed to prevent and repel it, and the third requisite is that the person making the defense had no part therein. Arita sa defense of stranger, unlawful aggression, reasonable necessity of the means employed to prevent or repel it, and naglahi sila sa third requisite. Unsay third requisite? That the person defending be not be induced by revenge, resentment, or other evil motive. I hope you understand. And baka determine na mo kanos amo sulod si defense of stranger, kanos amo sulod si defense of relatives, o kanos amo sulod si self-defense. Okay, let us proceed to the next topic. Avoidance of greater evil or injury. Pinaka-importante ni siya nga inyong sabton. Why? As I have mentioned sa ako ang pagsugod ganiha, ganian ako about the avoidance of greater evil or injury. Nga kinira siya nga paragraph under Article 11 nga maheld siya civilly liable. Di ba ningon ko ganiha, justifying circumstances, it is an act of a person to be considered as in accordance with the law, and do not have transgressed, and he is free from criminal and civil liability. Naka-remember mo ato ni anak ko? Except paragraph 4 of Article 11. Kaya nga naman, naa kay civil liability diri. Timan ini, kaya nga naman, inigsulod na to exempting circumstances. Exempting circumstances, inigsulod na to, kay si exempting circumstances manggod, mausab na sa siya. Mausab na sa siya. Sa paragraph 4 gihapon. So, maabot rata dito. Now, ari sa paragraph 4 under Article 11. Avoidance of greater evil or injury. Or the doctrine of state necessity. So, what are the requisites? So, any person who in order to avoid an evil or injury does an act which causes damage to another, provided the following requisites are present. First, that the evil sought to be avoided actually exists. Second, that the injury feared be greater than that to avoid it. And third, that there be no other practical and least harmful means of preventing it. See, for example, A is a driver siya of a passenger bus. Drive siya. Nag-drive siya, acted with an ordinary due diligence as a good father of the family. Maram na i-require. Kay kung pananglitan, owner na siya sa bus, kaya ang required is extraordinary diligence. Ang require lang sa driver is the so-called ordinary diligence as a good father of the family. Mo na i-require lang ordinary diligence. So require naghimo siya na, yan ang gihimo, hinay kayang dagan. And then niabot sa punto nga naay 6x6 nga truck. Ha? Nga padung na sa iya mo igo. And now, wala na siya lain nga kapadaganan kundili adto sa katuang mga bystander nga naay, say for example, 3 to 4 persons nga naa dito. And then ang sulod sa bus is naa sa mga 80 or 100 ka mga tao na sakay niya sa passenger bus. Apply na to. That the evil sought to be avoided actually exists. Is there evil sought to be avoided? Yes. Nga naman, padung na niya ang 6x6 truck. Kung igo si A, dito sa 6x6 truck, pwede nga mapatay niya mga 60 ka mga pasahero niya kung dili niya mapangitaan ng pamaagi. That the evil sought to be avoided actually exists. Second requisites, that the injury feared be greater than that to avoid it. That the injury feared be greater than that to avoid it. Balik ko na ko kung muigo sa 6x6 truck ang passenger bus, pwede naa sa mga 60 ka tawo nga mga patay. Pero og iyahang iliko ngadto sa, say for example, sa mga bystander nga naa lang sa tulong ngadto sa 4 ka tawo, posible nga maluwas ang 60 nga kinabuhi nga iyahang pasahero ngadto sa 4 ka tawo nga iyahang posibleng maigo kung iyahang ilikay, og posible sad nga walay maigo kung iyahang ilikay. So, nata sa second requisite sa that the injury feared be greater than that to avoid it. Third, that there be no other practical and least harmful means of preventing it. Wala na'y lain nga pwede nimong himuon kundi kato na lang. Wala na'y practical or least harmful means of preventing it. Nakuha? Now, atong igo sa sitwasyon nga gilikay. Gilikay ni driver A ang iyang passenger bus nga posibleng moigo sa 6x6 truck. Iyang giigo dito sa mga bystander. Now, napatay ang 4 ka bystander. Naluwas ang 60 ka mga pasahero. Kay gilikay niya sa 6x6 truck. Naabay evil suit? Yes, there is an evil suit to be avoided. Naabay injury feared be greater than to avoid it? Yes, mas greater ang injury nga ma-incurred. Kaya nga naman, 60 ka mga tao ang mapatay. Except sa katong 4 nga iyang gihimo, posible pa nga di mamatay. But ibutang nato sa example nga napatay. Naaba siya lain practical and least harmful means of preventing it? Wala. Nga naman, naana siya sa sitwasyon nga between life and death, nga iyahan na nang i-decide kanang seconds lang or a click of kanang a seconds nga naadain mo kuan din siya og kanang desisyon. So mao to yang gihimo. Giigo niya ang bystander. Now, unsa giingon ganin ako ganiha? Under this paragraph, wala siya criminal liability, but naa siya civil liability. Therefore, ang mahitabuan ni, i-apply na to ang doctrine of necessity, doctrine of state necessity, pabayron si driver sa katotoang bystander, of course, nga namatay, pabayron siya. Kay mo may iyang gihimo, liable man siya civil liability. Di ba niingon ko, liable siya civil liability. Unlike sa first, second, and third, first and second, third paragraph of Article 11 of the justifying circumstances, self-defense, defense of relative, and defense of stranger, they are free from criminal and civil liability. Timan wala siya liability, both criminal and civil. Sa paragraph 4, dili siya criminally liable, but he is civilly liable sa iyahang giigo ngadto nga mga bystander. Nasabtan. Another example. Here is A. See for example, Miss Universe. Miss Universe Philippines. Now, girape siya, for example, girape siya og 3 ka tawo. And walay nakahibaw kundi iharang kaugalingon. Dayon, ni-result into sa iyang pagbuntis. Ni-result sa iyang pagbuntis ang pag-rape. Now, kay para protektaran niya ang iyahang kaawaw, nindool siya ni Dr. B. Nga, Doktor, tabangi ko sa akong problema. Kay, kanang na silbi na buntis ko, gusto na ko ipakuha. Kay kung di na ni mo buhaton, mag-suicide ko. Ha? Yan na siya. Kaya kung di na nimo buhaton, mag-suicide ko. Now, tungod sa kakuha ni Dr. B nga mag-suicide si Miss Universe A is iyang gi-abort ang bata, iyang gikuha niya. Now, ang gihimo ba ni Dr. B justifiable ba siya? Ma-considered ba nato as justifiable? The answer is no. Why? Asa mang evil so to be avoided actually exist and that the injury feared be greater than to avoid it? Wala, di ba? Kay ang pag-commit sa suicide is not a crime. Ha? It's not a crime itself. Naabay diha. Pero og ning assist ka in the commission of suicide, of course, that is punishable by law under the RPC. Pero og mag-suicide ka diha, pala ka labot, di ba? So, dili siya maingon nga naa kay greater injury than to avoid it. Therefore, dili pwede mo apply sa gitawag nato nga doctrine of state necessity. Ha? Dili pwede i-apply nato ana nga case nga moingon ka nga mag-suicide ka kung dili ipa-abort. No. Dr. B should not follow sa giingon ni Miss Universe A. Okay? Di ba niingon ta nga nanay rights ang bata diya sa sulod sa iyang tiyan. Ha? Now, alita sa gitawag nato nga mercy killing or euthanasia. Ha? Mercy killing or euthanasia. Is mercy killing or euthanasia considered as a justifiable grounds nga dili ma-held liable si doktor nga naghimo sa mercy killing? The answer is no. Nga naman, apply the doctrine of state necessity or the doctrine of avoidance of greater evil or injury. Kung imuha na siyang patyon, euthanasia, mercy killing, patyon sa doktor, kay para dili mo prolong ang iyang agony, parang dili ma-prolong ang iyang suffering. Asa ang greater diha nga injury? Ang magsakit siya or patyon sa doktor? Of course, kung imuhang patyon. Ha? Nga naman, gipatay naman nimo. Muna siya greater injury. Nga, kung imuhang patyon, asa imong gi-avoid? Based on my example ganiha, nga gilikay niya kay para ma-save niya ang 60 ka mga tao, iyahang giigo ang 4 ka tao. So, dito nga instances, masulod siya. But on the case nga imuhang gitawag nga adto ka atong facts, so dili nimo ma-apply ang gitawag nato nga kini ang avoidance of greater or evil injury sa mercy killing. Kay nga naman mas bugat ang kinabuhi sa tao kontra sa mag-suffer siya sa iyang sakit. Nasabtan. Now, last example on the state of necessity rule or the doctrine or the avoidance of greater evil or injury. Now, for example, si A nagbuntis siya. Now, kung pananglitan nga mo abot sa punto nga mapakataw ang bata or magdugay sa iyang tiyan is mamatay si A. Now, mo decide between the life of the mother and the life of the unborn child. Kay both of the life of the mother and the life of the unborn child has the right, na siya right nga mabuhi. And in fact, it is provided under our Constitution. Now, niya na nga pilion ang kinabuhi sa mama kay kontras kinabuhi sa bata. So, mo to, gipili ang kinabuhi sa mama kontra sa kinabuhi sa bata. Now, justifiable ba ang gihimo sa usa ka doktor nga gipili ang kinabuhi sa mama kontra sa kinabuhi sa bata? The answer is yes. Nga naman, justifiable siya nga naman kay mas greater ang loss or injury kung mamatay si mama. Nasabtan? Dili man na ingon nga gi-discriminate nato or atong gi-kuan ang life of the child compared to the life of the mother. But based on my facts, applying only for educational purposes, ako magitagaan og dakog bugat nga value ang mama, then the act is justifiable. However, on some instances where naglisod na gid maayo ang mama, nga wala na gid siya chance, din imo yung isave ang kinabuhi sa mama, din even though nga healthy kayo unta nga mapagawas ang bata, imo gyapon gipili ang mama, ni resulta hinuon nga namatay ang duha. So in that instance siguro is na kay liability, di ba? But on my example, for educational purposes only, gitagaan ako big gibug aton ang life sa mama para mosulod nato sa greater evil or injury. Ha? To avoid greater evil or injury. So, nasabtan. Again, under Article 4, timan-an ninyo nga gilikay sa panghitabo sa greater evil or injury in order, muna yung pinaka-importante, in order to avoid it. And there is no other practical or less harmful means of preventing it. I hope you understand. I hope you understand under paragraph 4. And of course, paragraph 4, maoray na lahi sa tanan. Among of the 6 defenses under Article 11, kiniraang na ay civil liability. Now, performance of duty. So, nanata sa paragraph 5. Paragraph 5 sa justifying circumstances, performance of duty. I already mentioned about this performance of duty on the case of People versus Owanes. Katong akong gi-mention, akong gi-distinguish versus katong case ni US versus Achong nga nag-mention ta ato about mistake of fact in which nga ning-ingon ko nga the act of Achong is in accordance with the law because his act is justifiable, his act is on the ground of self-defense. Nga ning-ingon ko nga there was unlawful aggression, there was reasonable necessity of the means employed to prevent or repel it, and there was lack of sufficient provocation on the part of Achong to defend himself. Now, akong gi-contradict siya or gi-distinguish on the case of People versus Owanes where the peace officer serving a warrant to a certain wanted person, there was unreasonable force or unnecessary exercise of his performance of their duties where si wanted person is natog gahapa dito sa iyang bedroom, open ang door, is wala gi-clarify or gi-determine first ni peace officer kung si wanted person bagina siya ang naghigda dito. Si wanted person ba yun? So, imbis nga na pa sila enough time to determine is wala ilang gihimo, gilargo og pusil. So, meaning to say, on that case of People versus Owanes, na ay nahitabo nga negligence on their part. Since there was negligence on their part, they cannot invoke this performance of duty or lawful exercise of his right or office. Okay? Sabdan. Nga naman, under paragraph 5, nasa tayo requisites. Ganihan, paragraph 4, namatay requisites. Diba? That there must be an evil suit to be avoided, that there must be greater injury to avoid it, and there must be no other practical or less harmful means of preventing it. Naatay mga requisites, every nga mga defenses under justifying circumstances, kindly memorize all those circumstances ay requisites para dili ka masaag. Now, first requisite under paragraph 5, that the accused, so atong ibutang nga accused is of course si law enforcement officer. Nga naman kay siya may nakapatay. Siya may nakapatay in the performance of his duty, di ba? So the accused perform or acts in the performance of his duty and in the lawful exercise of his right or office. First requisite. Second requisite is that the injury caused, ang injury nga imong nahatag sa victim or the consequences of the offense is on the ground of the due performance and the lawful exercise of his right or office. Meaning to say, ang gihimo sa police is reasonable, ang gihimo sa police is lawful. Lawful and in the due performance of his duty. Now, going back on the case of People versus Owanes. On the case of People versus Owanes, the act of the peace officer was not in accordance with the law. Why? Because they have enough time to determine kung kinsa to ang tao nga naghigda dito sa bedroom. Gaghukas ng talikod. Nga ilahan na lang hinuong gipusil, without determining kung kinsa to ang naghigda. That is in the case of People versus Owanes. So therefore, on that case, dili ta pwedeng mo apply sa gitawag nato nga in the performance of his duty. Therefore, na-held liable sila. Okay, nasabtan. However, in the case of People versus Felipe de Lima, in the case of People versus Felipe de Lima, ang nahitabo ani is that si Felipe de Lima ay si Lozano si Lozano kay si Felipe de Lima, of course siya man ni ang gitawag nato nga peace officer kay siya may nakapatay ni Lozano. Si Lozano is an escape or escape siya from serving his sentence, and now gigukod siya sa mga peace officer. So until such time nga niadto siya sa balay sa iyahang amigo, and then pag adto niya sa balay sa iyahang amigo didto nakuha niya na nasundan siya sa mga police officer. Then about na siya nga i-arrest sa peace officer is naa siya gitawag nato nga mura og bambu nga hait kistanan og iyahang gidugsak-dugsak sa mga peace officer. On the first nga gihimo sa peace officer is of course ning sokol sila. Pagpusil is wala na igo. Wala na igo. Then continue ra gihapon si Lozano nga para di siya madakpan. Gisigin niya dugsak si peace officer. Pagdugsak then didto pagsikan na pagpusil na igo si Lozano. Now, pangutana, is the act of the police officer nga para i-effect ang arrest against Lozano valid ba siya and justifiable? Balik ta sa requisites. The accused perform her acted in the due performance in the lawful exercise of his right or office. First requisite. Second requisite, that the injured caused or the consequences of the offense is based or is due to the performance and lawful exercise of his right or office. Nag-act ba siya in the due performance of his office? Yes. Ang injury, diyon sa kapag-caused. Unsay rason nga or consequences of the offense? Di ba? Kay tungod kay dili siya gusto madakpan, ning sukol siya sa mga peace officer, ning sukol siya sa police officer, mo to siyang napusilan. Kay kung dili to mapusilan, of course, kaya nga gidugsak-dugsak nga kawayan, pwedeng masamad ang mga peace officer. So therefore, ang gihimo sa peace officer, sa mga peace officer, in the case of People versus Felipe de Lima, is justifiable under paragraph 5 of justifying circumstances. Nagkasabot. So, muna yung timaan. As long as ang gihimo ni peace officer is in the lawful exercise of his right or office or in the performance of his duty, of course, pwedeng ma-invoke ang paragraph 5. Now, alita sa gitawag nato og lawful exercise of office. Say for example, na si Dr. A, naasag si patient B. Alita sa office. Alita sa office. Now, si Dr. A is iyahang giputol. Iyahang potlon ang tiil ni patient B kay tungod gikang grina. Tungod kay diabetic ba. Grabe na kaayo kay kung dili putlon si maabot sa diri sa kuan, si for example ari na mahurot na gid padung lawas. Now iyang giputol ni Dr. A. Pangutana, is the act of Dr. A justifiable under paragraph 5 of the paragraph 5 of article 11? The answer is yes. Why? Ni-exercise siya lawful exercise of his office. Kaya iyahang na siyang duty nga iyang i-perform. Nga iyahang putlon ang tiil kay para maayo. Kay kung dili pa, of course, mahid liable siya for mutilation. Or ang imuha baron dihang kuan kay capable of reproducing man. Kung may tagi mutilation, ang imuha baron diha giputol. Kay nga na ay kuan ng sakit niya og putlo na siya kay mabuhi ka. So dili siya mahid liable for mutilation. Nga naman, that is your ni-exercise ka sa imuhang lawful exercise of your office as a doctor. So nasabtan ang paragraph 5 ha. I hope wala may pangutana ani sa paragraph 5, and if you have questions regarding this, you can comment below kung naa may mga pangutana regarding sa paragraph or any other paragraph under article 11 of justifying circumstances. Now let us proceed to the obedience to order of superior officer. So kining obedience to order of superior officer, of course na nasa tay gitawag nga mga requisites. Under paragraph 6, ang i-provide niya is any person who acts in obedience to an order issued by a superior for some lawful purpose. First requisite. Ang giingon sa first requisite that the order is issued by the superior officer. Second requisite, that such order must be for a lawful purpose. And third requisite, that the means used by the subordinate to carry out such order must be lawful. Okay. Now, the superior and the subordinate must act siya within the limits prescribed by law. Otherwise, kung wala pa siya, then they may held liable and they cannot invoke paragraph 6 under article Article 11, paragraph 6 of the revised penal code. See for example, ningon si superior officer nga o subordinate i-torture si B until death. Torture B until death because he did not obey my instruction or he did not follow my request nga, si for example, dalhan kog isda nga mga basta sa iyang request wala gisunod. Now, gisunod ni si for example ni subordinate ang order ni superior. Now karon iyang gitorture hantod namatay. Now, pangutana, maka-invoke ba sila sa gitawag nato nga kining paragraph 6, obedience to order of lawful order or order issued by superior for some lawful purpose? The answer is no. Kanus ana hitabo nga lawful ang pagtorture sa katao. Di ba? Unlawful, that is an illegal act. Therefore, dili siya maka-invoke og diri sa obedience to an order issued by a superior for some lawful purpose. Another example. What if nihatag og order si superior to subordinate B and subordinate B is without any idea. Wala siya idea kung unsa about ang illegal ba na siya or lawful ba na ang iyang gisugo sa iyang superior. Ang iyang gihimo is to follow or to obey the order of his superior. So in good faith siya nga iyang gihimo. Now, kay in good faith man siya nga iyang gihimo, then kung naa man na siya effect nga illegal ang mga mahitabo, pwede nga dili ma-held liable si subordinate. Nga naman, klaro raman kaayo og tataw sa atong requisites. Unsay gingon sa requisites? That the means used by the subordinate to carry out the order of the superior must be for lawful purpose. And in fact, based on my facts, ni ana ko nga acted siya in good faith, meaning wa siya knowledge about the illegal purpose or order of the superior officer. Ignorantia facti excusat. So meaning he acted, natay gitawag mistake of fact na sadda. Gihimo niya nga walay negligence, gihimo niya nga walay intent, gihimo niya nga lawful ang iyang purpose. But it resulted into the different effect nga illegal day ang intention sa katong order ni superior officer. Okay, nasabtan? See also for example, in the case of serving a search warrant, of course, lawful order man na siya from the court. Then, of course, as a police officer, subordinate siya, so iyan ang i-follow. And must be in a reasonable force. No any unnecessary force to effect or to arrest a person. Must be necessary. It must be reasonable para musulod ta sa paragraph 6. I hope you understand all the different circumstances or the defenses under article 11 of the revised penal code. So let us proceed on the battered woman syndrome. This battered woman syndrome is defined as a woman who is repeatedly subjected to any forceful physical or psychological behavior by a man in order to coerce her to do something he wants for to do without concern for her rights. Battered women include wives or women in the form of intimate relationship with men. Meaning to say, na ay gitawag na ito nga sexual relationship, marital relationship or dating relationship. Furthermore, in order to be classified as battered woman, the couple must go through the battering cycle of at least twice. So mayon ta og battering. What is battering? Battering means any physical attack, psychological abuse or emotional abuse nga imong gi-inflict on your partner. Of course, katong naay sexual dating relationship and maternal or namoy relationship as husband and wife para musulod ta, or namoy relationship as girlfriend, as boyfriend, or unsa inyo ha mga dating relationship para makasulod ta sa battered woman syndrome based on the battering act. Meaning there must be a physical attack, there must be a physical abuse. At least twice, meaning to say there must be a cycle of violence. When we talk of cycle of violence, of course, natay gitawag og stages or phases. in the cycle of violence. First, we have the so-called tension, tension building phase, meaning nanadiha ang panaglalis, nanadiha ang away-away sa first cycle para matawag ta og cycle of violence. Nanay panaglalis, nanay away-away, nanay silosilos, or nanay mga unsa diha nga wala mo nagkasundo. Second, or the second stages in the cycle of violence, kinahanglan na gitawag nato nga acute battering phase. Unsa man ang acute battering phase? Gikulata na ka. Gikulata na ka or gipasakitan na ka, whether emotionally, whether psychologically, or whether economic abuse, or of course whether physical abuse gagihimo sa imong partner. Muna nang gitawag nato nga second phase of the cycle of violence. And third is the tranquil loving phase. Human naglalis, gikulata, pagka human naglablab, mugbalik. So balik-balik. So balik na sa ka, naglalis, gikulata, naglablab mugbalik, nagbalik na sad, naglalis, gikulata, naglablab mugbalik. So meaning at least twice nagabalik-balik na siya nga cycle of violence din masulod si battered woman. Battered woman, muna siyang battered woman syndrome. Now, nganong gi-appeal man siya on the discussion about the justifying circumstances? Because natay gitawag og battered woman syndrome defense. So pwedeng mo dipinsa si asawa or si any partner kung naa na to ang cycle of violence. And in fact, in applying this battered woman syndrome defense is that dili necessary nga naa si unlawful aggression, dili necessary nga naa si gitawag nato nga reasonable necessity to prevent or repel it. What is required is that there must be a cycle of violence, there must be a physical abuse, there must be a physical attack at least twice, and of course giprotektahan nimo imong kaugalingon against injurious or any fatal attack against your partner. So mo na siya ang battered woman syndrome defense. So pwede ka ana nga madili criminally and civilly liable. So if those circumstances is masulod based on the akong gipang mention nga mga phases or stages in the cycle of violence. I hope you understand about this battered woman syndrome defense. So we'll proceed on the doctrine of self-help under Article 49 of the Civil Code applied in criminal law. So why I include this doctrine of self-help? Because it is part of your justifying circumstances. Provided that you are the lawful owner and the lawful possessor of the property, then you can protect such property. However, when A, say for example, nangawat siya sa balay ni B, iyang silingan si C. So nakita ni C nga nangawat si A sa balay ni B, iyahang gipusil si A. Question, is the act of C nga iyahang gipusil, iyahang gipusil si A nga nangawat sa balay ni B, ma-apply ba sa doctrine of self-help? The answer is no. Why? It is very clear under this Article 49 of the Civil Code that the one making the defense must be the lawful possessor or the lawful owner of the property. Hence, C is not the lawful possessor or the lawful owner of the property. He is only the neighbor of B. Then he cannot or he cannot make any rights to protect the right of the property, or else pwede ra siya ang iyahang mahimo or marimedy is iyahang badlungon but not to kill A. Ang iyang himuon lang is iyaha barong i-report or iyahang i-arrest if naa siya'y guts to arrest, kay na may citizens arrest, dayon iyahang dadon dito sa police station, di ba? Nung kay iyahang patyon. Kay when we talk of doctrine of self-help, ang pinaka-importante is you are the lawful possessor. Meaning to say, wa ko niingon nga ikaw ang lawful owner, possessor man ka, so ikaw ang nagbantay. Meaning og lawful owner, of course, you are the rightful owner of such property. Lawful owner or lawful possessor to protect such property. Mo na say doctrine of self-help. Sabdan. Another example, kung pananglitan ikaw ang nagbantay, dayon wala ka giposil or wala ka gi-attack, nga nakita nimo diha nga si for example, nakita nimo nga padungis lang mosulod nga imong giposil largo. So in that case, but by the book man ta, makaingon ta nga walay doctrine of self-help nga naman. Ang ilahang intention is not to kill you man. Ang ilang intention is to rob, si for example, sa property nga naa dito. However, kung pananglitan gi-attack na ka, of course you have the right to defend yourself. So pwede na ito masulod na sag-ang self-defense. So it depends upon the circumstances. but we will stick on the definition or on the provisions provided under Article 429. It must be on the mo kuha sila intent to gain the property within your vicinity. So, and you are the lawful possessor, you have the right to protect such property. Nasabtan ang doctrine of self-help. So, I think I already discussed all those circumstances that will protect you from any civil and criminal liability as long as you are in accordance with the requisites provided in every paragraph. Otherwise, if dili siya makumpleto ang requisites, of course, mosulod da sa mitigating circumstances, which is also part of the factors that will affect criminal liability. However, on that cases na mag-mitigating na ka, dili na ta makaingon you are free from criminal and civil liability. And that's the end of our discussion about justifying circumstances. I hope you understand more about the different requisites and when and how you will defend yourself against the aggressors of any person that they wanted to prejudice your rights. Thank you and God bless, and be updated on the next video.